Ladies and gentlemen, welcome, and thank you so much for coming to our panel, The End of Anonymity, Threats to Privacy in a Brave New World. As you can see from our alarmist title, privacy advocates have a fondness for predicting the end of privacy in the most catastrophic terms. But it's true that for the past 8 years, we've seen a series of threats to privacy that I certainly couldn't have imagined when I started writing about this topic in the misty days of the Clinton administration, from secret surveillance and scandals involving wiretapping to ISP privacy, scandals involving the revelation of search terms of users, to recent headlines involving the privacy of federal judges. This is an issue that has consumed the country and may be an issue in the presidential campaign. We have a wonderful panel to discuss this topic. We're going to try to entertain you and ourselves by keeping things lively and conversational. And let me introduce my colleagues, and then we'll jump right in. To my left is my colleague and friend Oren Kerr, who's a professor of law at George Washington University and nationally recognized expert on national security law, criminal procedure, and computer crime, and a blogger at the Volokh Conspiracy. Next is Leslie Harris, who's the president and chief executive officer of the Center for Democracy and Technology and a former director of public policy at People for the American Way. In the middle is Melissa No, who is a privacy and information consultant and publisher of privacylives.com. And to my left is Marcy Wilder, who's a partner at Hogan and Hartson, an expert on the health information privacy regulations, which she helped to draft in government service, former general counsel for NARAL, Pro-Choice America, and most important of all, the single most impressive pre-lawyer credential I've ever heard, a former stand-up comedian. So if things flag, she's going to keep us entertained. And I'm Jeff Rosen, a professor at GW, where Oren also teaches. So let's jump in by beginning with threats to privacy in the private sector. This is a world where more and more of our lives are lived online, where our search terms and emails and documents are often consolidated at the ISP level or in places like Google and Yahoo, and can be scanned and searched and potentially revealed in ways that threaten our privacy. Leslie Harris, you have thought very deeply about these issues. I want to ask you, what is the greatest threat to privacy? In concrete terms, help us understand, what should a citizen fear from this new world of data collection at the ISP level, and what could government do about it?
Well, I think that, I think you have to back up a little bit and understand that we're operating in a digital universe where we have legal standards that at best are 20 years old and at worst don't exist at all. So we can talk about the commercial, which I'll talk about right now. We can talk about what's going on in the internet cloud. But I think it's really important to understand that there has been, I think, over the last 8 years, sort of an intense focus on what's happening around national security standards and access, and sort of a full debate and disagreement about those laws. I think what's been lost is that our traditional Fourth Amendment standards are so eroded because of the rapid evolution of technology and trying to apply laws like the Electronic Communications Privacy Act that didn't even anticipate the World Wide Web. Sure. There seems to be like a strange bump under here. Okay.
It's just the NSA.
Yeah. It's a, thank you, right.
They don't need mics for that.
They absolutely do not need mics for that. So that when you look at any one of these, issues that we're going to talk about, we're talking about it in a context where, law is completely outstripped. So on the, so where we are on sort of internet service providers is that, we started off where they were like telephone carriers and covered by common carriage laws, and we now have ISPs who are considered information services who have technologies like deep packet inspection that not only make it possible to pull apart and look at all of the packets, but in fact, the government now requires them to have technologies under CALIA to do that. And they are, I think, increasingly trying to figure out the commercial value of all of the individual data streams that come over their wires, and how to pull those apart and participate in what's become this enormous new behavioral advertising world, already happening out there in the internet cloud, the pulling of all kinds of discrete information about you, which we can talk more about, and pulling them together either directly or with a third-party advertiser into profiles. You are a, suburban mom who buys cars, or, a variety of other kinds of things into these profiles, and then serving up ads. And it probably violates the Electronic Communications Privacy Act, but you're looking at a law that never even anticipated that this was what was going to happen in those kind of communications. So you have those pressures, and then you have pressures from other entities to make them look at your data stream. You have the intellectual property holders who are trying to force them to filter the content coming through for IP violations. You can't do that unless you're either looking at a watermark or looking at something else. And you have, I think this week, revealed, deals with state attorney generals to filter or somehow look at packets for child pornography. Even if we believe you know it when you see it, you still are going to have to be pulling all these packets apart. So the ISP is suddenly in a totally different place than I think we, when we signed up 25 years ago for CompuServe or AOL, that we could have ever imagined.
So that's very helpful lay of the land, and you've reminded us that ISPs hold all of this data, there's not a lot of legal protection, and they can do a lot of things with it. But concretely, I want to ask my colleague Melissa, maybe you could weigh in on this. What can this audience fear from this world? Behavioral advertising people say, if I'm just getting targeted ads, I don't care that they know my data. What's the particular danger? Is it that my search terms might be leaked in personally identifiable ways, the way AOL leaked them through an accident? Is it something else? I want to know concretely what the threat to privacy is.
I think it has to do with the belief that they're allowed to gather your personal information and reuse it for their personal or professional targets. For example, yes, they do gather your search terms, they gather the websites that you're looking at, and sometimes with Gmail, they look into your email for certain target words. And this information is gathered. This information is possibly kept. We don't really know much about what they do with the information. And therein lies the question, what are they doing with the information and who has access to this information? A couple of years ago, the Department of Justice came to the various search engines, Microsoft, Yahoo, Google, AOL, and said, we want these hundreds of thousands of search terms from this 2-month period. Everyone except Google handed over the information, and Google said, no, this is not information that you should have. You have no reason to have this. Long story short, lawsuit. What comes down to it is that websites were turned over, millions of websites that people visited in that time period, but not their search terms, because the court said that there was an expectation of privacy in this information. And when you think about it, is this the information that you really want out there? I mean, yeah, it doesn't really matter if people know that you're looking for a new car, but some of the AOL searches involved looking for particular diseases and also other kinds of more personal information that you don't really want out there, you don't want gathered by someone else, and you don't want repackaged and reused without your permission.
Very good. So Melissa gives us a concrete fear. The government could ask for search terms, When they did that, only Google resisted, but Google still holds all of this information, and it could be very embarrassing to have your search terms revealed. Oren, you've been an eloquent skeptic of some of the hysteria of privacy people like me and others. Is Melissa's fear overstated, or is she right? For example, the Chinese government asked Yahoo for search terms related to national security secrets. Yahoo handed it over, and a Chinese dissident was thrown in jail. Has Melissa identified a real danger of a world where ISPs hold all of these search terms?
I think we need to break it down a little bit. So there are a couple of different issues here. One is search terms. What happens to search terms when they are received by a search engine? Does Yahoo or Google, what rights regulate the privacy of that information? The other question is, what about the ISPs that have the search terms going through them merely as conduits? And I'm worried about the former and not worried about the latter. I'm worried about the former because, believe it or not, there is no search engine privacy law. And in fact, I'm writing an article this summer on why there needs to be a Search Engine Privacy Act. Once you send your queries to Google, there's no reason that Google should have them in a way that can be disclosed to the government under a mere subpoena standard. That means that the government can just get it just to make sure you're not committing a crime. Isn't that helpful to know? So there's no reason that information shouldn't be protected. What's fascinating about this is just as a matter of practice, the government has generally taken a hands-off view towards search terms. Usually because it's very hard to figure out what IP address the person was coming from. The information would be stored by the search engine as a connection between an IP address and a search term. That's generally not going to be helpful information from the government. Once they know the IP address, they're going to instead be interested in getting a warrant to get somebody's computer, to look through the computer itself, the actual hard drive, which is going to have the information more than the search terms. But that information can be very invasive, and I think the district court judge in the Google case recognized that, was very creative in trying to figure out a way why the subpoena needed to be modified. Whether that was legally persuasive or not is another question, but I think there really is a need for some sort of law along the lines of the Electronic Communications Privacy Act, which was dealing with ISP privacy, privacy from ISP monitoring, applied to search terms or search engines, search companies like Google and Yahoo. I'm less worried in the ISP setting because the law here is that search terms are considered content, so the rules that ISPs need to follow in order to access search terms, say, that are going through them as conduits, are the same as they are to listen in on your telephones in the case of a telephone company, or read your emails in the case of content email in real time. And in that case, they need your consent to allow it, or else it's a criminal and civil violation with attorney's fees, punitive damages, and all the like. So I'm not as worried in the ISP context, but I think there's a very real issue in the search engine context.
Great. So now we're getting somewhere. Our bipartisan panel has identified a concrete danger that Leslie and Melissa have stressed, this danger of having your search terms inadvertently revealed, and also a potential solution. Oren suggests a National Search Term Privacy Act. Marcy, you have worked on the health information privacy regulations. I want you to help us think through the politics of privacy if Oren's bill were to be proposed. Privacy is generally a bipartisan issue. Civil libertarian liberals and libertarian conservatives joined in opposing the Patriot Act. And the Clinton-Gore administration supported a lot of the invasions of privacy that ended up in the Patriot Act. So Democrats have no monopoly of privacy virtue here. But in the upcoming presidential campaign, there's an interesting statistic. Obama has an 82% lifetime approval rating from the ACLU, and McCain's is 25%. Would there be a big difference between Obama and McCain on privacy? And could you imagine Obama, our first civil libertarian president, actually championing the bill that Oren suggests? And might Congress pass it or not? Think us through these issues.
I'm sorry, I was preparing for the biggest threat question you asked everybody else.
Oh.
So, no, it's okay.
We'll get back to it. There'll be plenty of times to talk about biggest threats.
It's fine.
We'll come back to it.
I think the politics of privacy is going to depend almost entirely on the context. I think that in national defense, or national security, you're going to find a big difference between where McCain and Obama land. And in, for example, healthcare, you're going to find not that great a difference. So it's really, I think it's really going to be context specific. The interesting thing on the health side is everybody seems to agree that health information technology is going to help improve the healthcare system, it's going to make it more efficient, it's going to improve quality, but sort of the rap is privacy is holding things up because people are worried about it and don't know what to do. I think that the biggest threat in the healthcare context and across the board is actually a lack of transparency and a lack of knowledge. That is, what are we doing when we type in the search term? There is the entire back end of looking into what's coming across the wires or looking what's in the big pot of data goes on underground and in the dark. And the debate or trying to figure out, and this is true on both sides of the aisle, trying to figure out what should we do and what should the rules be requires that we shine some light on what's going on. And frankly, the people who are doing the looking, that's not so much in their interest. And so I think that, I think that the biggest threat is people don't know, folks don't know, I'm just using a service, I'm just using my search term and I'm getting good stuff and I'm liking it. And I don't really know what's going on in the back end. So if you look at healthcare, you've got folks, you've got this new world of personal health records. This is going to be great because right now you have a right to your health record. You have a right to see it. But when you ask for it, you get a big, thick file with a lot of paper that you can't read and neither can your other healthcare providers for the most part. So this notion that somebody's going to take that information and put it in a format that you can read and understand and use is terrific. But we don't know what goes on behind the curtain. And if we're going to use Google Health or we're going to use Microsoft Health Vault, what am I worried about? I'm worried about, is my employer going to have access to that information? I'm worried about, is some employee going to take that information and commit medical identity theft? I'm worried that when my service provider is moving the servers, right, because they're upgrading their systems, that someone is going to forget to put up a firewall and there it is, it's going to be out on the internet for folks to see. And there's a real question as to what should the rules be and what is the role, and this goes past the healthcare context, what is the role of consent and consumer control? Because I would say not so much.
Good. Well, you have just added an amendment to Oren's bill, perhaps, and said if we're drafting the search term bill, you want transparency and accountability and access controls. Google announced not so long ago that it will destroy personally identifiable records after 18 months. Maybe you'd want to require all ISPs to say what they're doing with the information. Maybe they should destroy the information more quickly so the two things can't be linked. Leslie, you want to weigh in? And I do want to press on this question of politics because we have the possibility of a new administration for the first time in a long time. The Democratic candidate is calling on the stump to restore habeas corpus, something that would have been inconceivable recently. Can you imagine, you do this legislation in town and you know this better than anyone, would a President Obama propose the kind of bills that Marcy and Obama and Oren are talking about, and might Congress actually pass it?
Okay. I will actually answer it, and then I want to make 3 points. It's nothing like being a nonpartisan organization who doesn't really want to answer the question about which candidate is going to do what. Okay. Obama, in fact, has already released in his technology policy agenda a number of proposals that sort of deal with this lack of privacy in the cloud. So would Congress pass it? Yeah, I think we've reached the point. We've had enough fire drills, but I don't want to pass Oren's bill. So
why not?
Well, for a couple of reasons. So Marcy touched on it. So first of all, search is too narrow. Let's understand that we live our lives online, and what's not being protected is not just search terms, but any information that we store online. And without wasting our time, notwithstanding the fact this is a legal conference on how we got there, the short version is that they're mostly treated as business records that you have no expectation of privacy in. So whether you're putting your itinerary all over Doppler, or your photographs all over Flickr, or your stored email that happens to be stored for more than 180 days, which I believe was an inconceivable idea when they wrote ECPA, or, increasingly when you start to think of convergence, where we're talking about the internet and then we're talking about mobile phones and a variety of other kinds of things, we're talking about location data. All of this is accessible under extremely low legal standards if it's stored with a third party, and it is stored now in a digital way where it's all interconnected. So that's number one. So I think we have to think broader. Two, I think consent is extraordinarily weak protection. If you ask consumers on the internet, and this goes back to the transparency point, what's going on out there and what they want to have happen or not have happen, we have an alleged opt-out regime for all of this commercial collection. Most people can't even figure out how to do it. Most people don't even understand that cookies are collecting this and that they could just set their third-party cookies. So you put everything on the consumer with consent, and frankly, in the ISP model, where I agree with Warren that right now ECPA probably requires consent. I think that's the most, it'll be buried in some terms of service somewhere, and you'll sign on the dotted line, and the ISP will, divert your data stream and create profiles about you.
Great. I know, Oren, you want to respond to Leslie, but in addition to defending your private sector search term bill,
Which I like.
You like, but it's not broad enough.
Not enough.
I then want you to broaden us out again, and as legislator-in-chief today, give us your government surveillance ideal bill. How would you, Oren has thought a lot about the Foreign Intelligence Surveillance Act and secret surveillance, and if you were an advisor to, say, Senator McCain, how would you...
A little more likely.
A little more likely, yes. What would you suggest to him would be a fix for the government surveillance problem that you've identified?
Well, the government surveillance problem is so broad. It really, I mean, one of the problems I think we're having on here generally, and this is very, very common in these sorts of discussions, is that surveillance is not sort of a thing. It's a general category of things. We use this one word because we're used to telephone wiretapping being our only kind of sort of surveillance we can understand, because that's what happens in the movies. We see that, so we're comfortable with what that means, and so we use the word. And what we have, we're sort of moving to a networked environment where that one word, surveillance, ends up being used to mean dozens of different things. And I think we really need to go issue by issue, context by context, and think about them separately. In terms of the Search Engine Privacy Act that I'm talking about, I'm really thinking of it primarily as a privacy law that would regulate against government access. So, for example, a warrant requirement for the government to access search terms is what I have in mind. In fact, I could think you could have a flat ban on access to search terms by private parties, because it's sort of unclear in what setting would there need to be private party access to someone else's search terms. Maybe in some cases, but not in many. On the broader question of where the law is, in responding to Leslie's take, I'm a little bit less worried about the current state of the law, in part because there have been some really interesting legal developments recently which have offered a much more privacy protection than we thought we had just a few years ago. And a couple examples of this: there have been a couple federal court decisions saying that there's a Fourth Amendment reasonable expectation of privacy in remotely stored content. One decision, the Warshak case from the Sixth Circuit, is currently pending rehearing en banc, so we don't quite know what's going to happen with that. But the basic insight of that case, which is that there's a reasonable expectation of privacy in stored content, was picked up by other courts. For example, a district court in Massachusetts said there's a reasonable expectation of privacy in picture files, image files stored on a password-protected Sprint website. So what we've got here is a notion which I think is actually pretty remarkable if you think about it. It actually says there's in some ways stronger privacy protections online than offline. You can get a virtual home anywhere online to store your private images, to store your contents. Not only do you have to go to your personal home or your personal space, you can establish personal space anywhere on the internet and have that full Fourth Amendment protection. We don't know the parameters of this. The law is still pretty unclear, but that's an important development that at least applies to content information. There's an important emerging line in the cases between contents and non-content information, which is not protected. On the question of consent, I think that if somebody says, yeah, you should be allowed to, I consent to this surveillance, I want this ISP, and I'm willing to agree to a certain type of monitoring in exchange for the service, I think as long as the consent is knowing and is made in light of real notice, that it's fine, that that's a choice that consumers can make. I might not want to make it, but there are lots of different ISPs and lots of different services, and we can make that choice. Importantly, under the Wiretap Act, which is a lot of what we're talking about here, consent has to be consent in fact. There can't be sort of, you should have looked at that long list of terms nobody looks at, and if you'd looked at it, you would have noticed it, and then you would have consented. No, that doesn't count. It has to be actual consent in fact, real notice provided, and under that standard, I think that's an important rule and makes me much more comfortable with the notion of consent.
Great. So Melissa and Marcia, we have two big topics on the table. One, Oren and Leslie have been debating whether it's better to have sectoral privacy laws or broader ones along the lines of the European Union. And then Oren just introduced another important topic about whether judges are better than Congress in protecting privacy. Melissa, what's your instinct on that question? When you think about the privacy issues you care about, would you put more faith in the next 8 years in the Congress and the President or in judges, and why?
Well, that's a big question.
Yes, it is. That's what we're here for.
And I don't know how really to answer that because, as with anything, it's context dependent. What is the Congress going to do in terms of what is it going to focus upon? We've found that if there is, say, a huge economic problem going on, then people don't look towards privacy as much. If we're in the middle of a war, then people aren't looking towards privacy as much because everyone talks about how if you support privacy, then you support the terrorists. So I think that it really depends on what happens. What are the cases that come to the judges? What are the bills that come up to Congress? For example, we have employment eligibility verification systems, and no one really understands what that means. What it means is that the Department of Homeland Security is wanting for employers to run people's names and Social Security numbers against their databases in order to prove that these people are eligible to work in the United States. The problem is that the Department of Homeland Security, the Social Security Administration, various other agencies in the government have said very openly that their databases are wrong, that there are millions and millions of incorrect cases, incorrect names, where people would turn up as people who can't work in the United States, even though they're citizens, even though they have every right to. And this debate in Congress has gone back and forth. People have said, oh, it's not a big deal because if you are able to work in the United States, you'll figure it out somehow. But I don't know about you, but I've gone to the Social Security Administration before in order to fix something, and it hasn't gone well. I'm actually a naturalized citizen, and I've been a citizen for many, many years, but about 6 years ago, I was told that I was not a citizen, according to the Social Security Administration, even though I've had a passport for much longer than that. So I had to go to the Social Security Administration and say, what's going on, what happened. They believe that the problem is that when I became a citizen, nobody updated my file. So it's been years and years where my file was not updated, yet somehow I got a passport. And I had to give them my passport. I had to give them my original naturalization papers. I had to give them my original Social Security card. And thankfully, I got all of that back 3 months later. But that's the problem, is because I had the time and the energy to take 3 days off of work over 2 months in order to go and do this, and I had that information. When you step back and think about it, how many people out there really have the time and the energy and the ability to go and do that, especially if what's hinging on it is whether or not they're actually allowed to keep their jobs. So I think when you step back and consider what's going to happen with Congress, with the executive, and with the courts, you have to figure out what exactly the context for all of this is.
Very good. Well, Marcy, everyone says context is important. You know about health care. The Democratic candidates have talked a lot about health care reform. When it comes to health care privacy in the next administration, who would you put more faith in? Another congressional reform, judicial action, executive initiative? Where is it most likely to come from in a productive way?
The next wave is going to come from Congress. I think that there is first of all, there's a big push because we want health information technology to move forward because it's one thing that will help the healthcare system, which is desperately in need of fixing. Folks don't see or agree on how to actually do reimbursement reform, universal health care, and so people like to focus on health IT because it's seen as a win-win. And again, it's bipartisan in the healthcare context. Everybody wants data available for good reasons, and everybody wants data protected against bad uses and disclosures. So I think in 2009, I think Congress is setting the table today. In 2009, we're actually going to see movement on privacy legislation, and the HIPAA regulations, which currently govern health care, were written really 10 years ago. Lots has happened since then, and so they need to be updated. More entities need to be covered, and they're going to do that with the support of whoever's in the White House, is my guess. So I think we are going to see reform around healthcare privacy. I think we are going to see enhanced protections, and that's going to be a unifying moment, as it were, as opposed to some of these other contexts where not so much.
Great. Okay, we've talked well about ISP and search term privacy and healthcare privacy. Let's zero in on national security privacy and the surveillance of terrorists. Obama has criticized the claim that the use of force resolution after 9/11 authorized warrantless surveillance. McCain, as I understand it, after having at some point questioned it, recently has enthusiastically defended the terrorist surveillance program as necessary to national security. Oren, just on, you know what I'm talking about, just on warrantless wiretapping. You are drafting the bill. What does it look like for McCain? Give us the Republican reform for wiretapping.
Okay.
Here it goes.
Here it is.
Great.
No. Well, first, the important caveats that you're supposed to give in all these settings. I am on the McCain Justice Advisory Committee. I know you wanted to be on it, but sorry, it didn't work out for you. That has no connection to any of this. This is obviously 100% in my personal capacity. I think the Protect America Act approach was actually pretty good. Terribly written legislation. Really terribly written. So it's one of those that led to field days of law professors blogging for hours and hours about what does this word mean and what does that word mean, which is really kind of fun in a weird way, at least for the first few days, but then gets kind of tiresome. But the basic idea, at least as we understand the legislation, that if somebody's outside the U.S. with no known contacts, involuntary contacts with the U.S., that they should be monitored without some sort of judicial oversight, I think is correct. The implementation is what really matters, and I think the idea of going to the FISA Court and saying, here's the methodology for establishing that this sort of monitoring is reasonably believed to involve people outside the U.S. In one sort of general court order, essentially, rather than individualized court orders, is pretty wise. And I think more broadly in this area, there's a lot of big picture constitutional law questions, a lot of questions. What is the scope of Article 2? What is the meaning of sort of the presidential power as commander-in-chief? But when you get down to the details, the area of disagreement is actually really narrow. It ends up being, you know, small, relatively small questions of should this particular type of monitoring require this sort of court order or another sort of court order? Very valid disagreements, and I'm not saying that there's sort of one right answer. But the area of disagreement, I think, is actually much smaller than you might think reading the paper.
So, Leslie, I want you to respond in a second, but is it right that everyone agrees now that warrantless surveillance of citizens, of people purely in the United States should not be authorized by law? And to the degree
You're
that
asking me?
Yeah, to the degree the
Yeah,
terrorist
yeah, no, I think there's no
Yeah.
disagreement on that.
Okay, and to the degree the terrorist surveillance program may have done that, then no one likes that anymore.
You mean I don't know if we even
We
know
don't
that
know, but
it
it's been
did
alleged,
that. But
certainly.
if it did do that, that was
Yeah,
bad.
okay. Leslie, tell us why Orrin is just way out there is destroying our civil liberties with this far too narrow bill, and what a better, broader bill might look like, and may actually pass, because we may have a president
Well,
who
you know,
actually
we're
wants it.
sitting here and they're cutting a deal on FISA even as we speak. But so Orrin mentioned the two places where I think there's agreement. I think there's agreement that you can wiretap people outside of the United States without going to the FISA court, and that we probably have to deal with that in some kind of baskets and, you know, FISA court approved guidelines. But the rest of that is not small matter. The rest of it is how do we protect Americans in that process, and that's where the disagreement is. And to me, that's not a small matter. I mean, the civil liberties community, which has not been completely together on the answers to that, believe that there is going to come a point where Americans become a target, and that you ought to have to go back and get a full FISA court warrant at that point. And, I mean, it isn't as if that's a particularly burdensome thing. I mean, if anything, the criticism of the FISA court has sort of been that it's a rubber stamp. And so, the question is, if we have a FISA court, are we writing out entirely their role in protecting Americans? Do you have to go back? Do you have to get a warrant? What are you going to do with all the data that you collect along the way that may become irrelevant on Americans? There's a lot of questions here, and from what I understand about what's likely to happen on the FISA legislation, I don't think we're going to get that level of protection. I think we're also not going to get an answer to what really happened, which we might get if the current cases were allowed to go forward. And I don't think we're going to get FISA legislation that's going to let those go forward in any meaningful way.
But Obama has criticized the FISA deal. Is there any scenario, if he won, under which FISA would be more or less restored to its pre-Patriot state?
If I were advising Obama, it's not where I'd go first. I mean, when I look back to Clinton spending his first 4 months having a fight about gays in the military, an issue I was working on, an issue I agreed with, I can't imagine. I mean, my understanding is the current deal that's being struck on FISA is 6 years, which is unfortunate. I can't imagine on day one him coming in and introducing a bill. Can I imagine it happening during the course of his administration? Yes, and it should. But I think that you come in and you're faced with all the things you want to fix and the enormous ability to be attacked around those things in ways that, that are, I think, extremely damaging to get your agenda done. So would I want to see them fix it? Yes, that's one of the reasons I would have liked this to have been a 2-year bill so that we could have a natural reconsideration. But, we got to see what Congress looks like. We got to see who wins and the size of that victory.
Forgive me for pressing one more question to you or to anyone else who wants to answer it, just so we all understand. What is the concrete threat of this FISA compromise? In what way does it leave Americans unprotected, and what should we be most concerned about?
Are you asking me again?
If you don't mind, or more.
No,
Yes.
it's fine. The concrete threat is that Americans will become targets in the context of targeting people abroad, and that we will not go back to the court and follow the rules that we have established for there to be Fourth Amendment protections in that circumstance. It pretty much, undermines the purpose of the FISA court in the first instance, and creates the potential that there's always somebody abroad that you can start with to get back to somebody you really want to look at as a target in the United States. So, I mean, I don't think it's complicated. I just think it kind of writes the FISA Court out of its own core purpose.
Thoughts on this question, Melissa or Marcy?
Well, the last I saw was the bond proposal, which included immunity for the telecoms. Now, is that the latest that's we're thinking is what's going to end up happening?
Well, it's going to be different. You're going to have to go back to the court to show that the United States told you it was legal. This is, I'm trying to follow this as sort of a rational resolution here, but this is my understanding. The cases would not be, maybe you know better than me, that cases would not be dismissed out of hand. There wouldn't be some sort of, and each case they would have to go and show the court that the government told them it was legal. So I think they've all got letters from the government, and they show them the letters, and the whole thing goes away. Whether there were other provisions in the bill that would allow the Congress and the American people to actually at some point understand what really happened, some kind of a commission, et cetera, I don't know if that's surviving. That language wasn't there.
Well, that is one of the biggest questions is if you give the telecommunications companies immunity, in this case, retroactive immunity, and there is no real investigation into what happened, is it saying that the Congress and the administration is okay with companies possibly breaking the law because the government told them to? And that, I mean, that is one of the biggest discussions around the telecom immunity. Is this what should really happen, or should we shine a light on what was actually happening and give the people the opportunity to understand the balances that were being struck when all of this happened?
Very good. Final thoughts on the NSA stuff, Marcy, or do you want to relate it to the healthcare debate?
Nope, I think we leave it there.
Okay. All right, well, then we have to turn to the future because we can't have a good privacy panel without scaring the daylights out of the audience. Oren and I were at a wonderful conference recently co-sponsored by Stanford and Google, and the following scenario came up. We were talking about surveillance cameras, which it's been proposed to expand in New York and D.C. and to create British-style surveillance systems where the government would have access to lots of public and private cameras. And the Google people said, that's nothing. In 10 years, 15 years, there are going to be increasing requests to put those surveillance feeds live on Google. Absolutely. And imagine a world, the gasp, that's what the privacy person always wants. Now we're talking, the gasp. Okay, so imagine this. This is really scary. Imagine, I should have started with this one, but forget about NSA surveillance. This is us, this is me, right. So you can click on your computer screen. Google Streetscape right now allows you to find still shots of places. And some people are objecting. Some women at Stanford were sunbathing in their bikinis, and they said, we're embarrassed, our picture is up online. So Google created a process where you could write in and have the picture taken down. But this is just, these are the Stone Ages. So in 10, 15 years, you click on to the Stanford campus in real time, click on a picture of the people who are sunbathing, back-click on them to see where they came from their house in the morning, forward-click on them to see where they're going, and basically make possible ubiquitous surveillance of anyone at all times by anyone. My fellow panelists, isn't this terrible, and what should we do about it?
Well, I want to make sure that we combine with that the fact at the same time that you're going to be one way or another either carrying around a location device or have one attached to a device that you don't know that happens to be a location device. So you have to put that together with the fact that you'll also have pretty close to real-time tracking of where you are, whether it's through GPS in your phones, whether it's through RFID attached to, the witty passport, whether it's your pass that you put on your car. I mean, there's or OnStar, whatever it turns out to be, there will be complete records that you'll be able to put together with the pictures so that we will not only know where you are, then we'll get to see what you were doing when you were there. So.
Okay, so what's the big deal? Nothing to hide, nothing to fear? Why should we be upset about this scenario of ubiquitous surveillance? Take it away, Leslie.
No privacy?
We already have zero privacy. Get over it, says
Yeah,
Scott McMillan.
I know, and that was 10 years ago.
Yeah, little did he know.
I think that, look, you can decide, and, there are arguments that we have an entire generation that doesn't care about privacy anyway and that's posting its life online. However, they seem to suddenly care about privacy when they get out of law school and get a job. I think it depends on where you are in the privacy spectrum. So you start off, either you think that privacy only matters when there's a concrete harm, or you believe that privacy is an inherent right and that you have a right to control personal information about you. So if you start from that position, then you're inherently violating something that's critically important in our sort of basket of rights. If you start from the harm side, well, then you just have to wait and see which harms develop out of this, which will be everything from, on the civil side to, unbelievable discovery over, any kind of small disagreements to the government being able to create enormous profiles on every citizen without ever having to come back to you at some, unless Oren's right and, the one case that we've got at a circuit court level is not reversed by the en banc review, which I think it's going to be. If nothing else, it's a crummy procedurally, and it's a crummy set of facts, and there's a whole lot of problems with that case that don't make me feel anywhere as confident that unless we completely change what we think about in terms of the legal regime that covers any of this, and all the pressures are in the other direction, because the pressures are for the next nifty technology that allows more and more and more, then we see everything else. Then we'll see the implications for people's jobs when people don't like what they're doing in their spare time, and discrimination about health care, and I'll stop and let Marcy pick up on that.
But Leslie, this is all happening to some extent now.
Yes, it's
and
starting
the question,
to happen.
and I think that the conversation, this notion of you paint the scenario and you say, what's the problem? And Leslie, you say, well, the problem is no privacy. Well, the answer to that is, so what?
Right.
And and that's the sort of the new generation that doesn't care about privacy. I think they do, but there's a bigger question here, which is first of all, one of the things that's creepy is it really highlights the loss of control that individuals have. The laws are historically set up, starting with the Bill of Rights, to control and limit what the government can do. Well, the government is still very relevant, but the private sector is even more relevant, I would argue, in many ways right now and in terms of where we're heading. So unless we start painting those pictures and describing in human terms what it is we don't like about it, because the way we talk about it today, we talk about the ick factor. That is not a great policy argument, the ick factor. And so we do this very specifically in healthcare. We do it with behavioral targeting. We need to start having this conversation in more concrete terms about what are the pros and what are the cons. And then the bigger question that I have is, once we have that conversation, it's not clear to me that it can be stopped anyway, because I already think technology is driving this in a way that the laws not only do not keep up, but cannot keep up. And so what do you do in that? How do you understand the stakeholders and their motivations? What can you do in the face of that?
Good. Okay. Don't fight the hypo. It's not a hypo. This is the Googleized world where you can click on the screen and ubiquitously surveil anyone at any time. The question is, first, is this a problem? Don't call it the ick factor. You've been a privacy moderate. Do you get off the boat here and say this would change the nature of our society? And second, can law or anyone else do anything about this?
I think it'd be terrible if this sort of thing were there. It's an obvious, great invasion of privacy. I can't see really any social purpose it would serve. I can't really see why people would want to spend their time following people around, except to stalk them, which is a bad thing. If in our hypothetical it's Google that's doing this,
They're just
then-
acceding to user requests to unite all the feeds of all cameras in the world on Google and other
It's
platforms.
just the aggregation of.
The aggregation.
the difficulty, or I think it depends on who's behind this. I think that really does change the picture. So if it's government, we can pass a law saying we don't want the government to do this. Don't fund this government. You're not allowed to do this. And usually, although as we found out, not always, but usually they follow those rules. If it's a company, then the company can be regulated. The company has stockholder interest. If there's protests by people, if the company is really tarnished, if its image is tarnished by something that people are greatly offended by, CEOs say, oh, wait, this is bad for business. So I think privacy is pretty good for business, as Google learned when the Justice Department wanted the search terms in the COPA litigation. And if there's public opposition, then it won't happen, in the case of businesses. The trickier case is, what if it's individuals? They can somehow set up this sort of a network. It's a lot more difficult to regulate individuals, particularly those that may be acting in some sort of a rogue capacity, than it is businesses, governments. Once you're talking about big entities with a lot of economic interests or interest in being reelected, they can be regulated by laws. So I think it boils down really at that point to what's our public reaction. I would oppose this sort of thing. I would guess most people in the audience would as well. But I think it really just boils down to what is our reaction and how to regulate.
Melissa, I know you want to jump in, but how likely is this to happen? So as Marcy and Oren have said, even young people who are happy to put all sorts of stuff up on Facebook care about control, and they become really upset when Facebook introduces a feature called Beacon that tells you what your friends have bought. So a woman learns that her fiance has bought her an engagement ring, ruins the engagement. Suddenly people are shocked and set up a protest thing about Facebook. So does that suggest that the same people who are happy to put up their cameras voluntarily would suddenly be shocked when the cameras were linked,
Yeah.
and they would feel loss of control, but might it then be too late?
Yes.
No.
Yes, and yes. Because, I mean, what happens is my reaction to the Facebook crowd being shocked was, what do they think is going on out there? It was only because they're part of a discrete community where they could see what happened that they were shocked. I think the problem is the average person has no clue that this is going on. So the idea that we're going to have people rising up, that's problem number one until it's too late. I think problem number two is, even when you tell people and explain what they need to do to become active participants in protecting their privacy, they either find it too technically difficult, or they keep thinking governments should somehow fix it. So you have this sort of thing going on in privacy where if you tell people what's going on and they understand it very specifically, they're shocked. But people take very little action to protect their own privacy. I mean, as I mentioned earlier, the whole behavioral targeting thing, at least today, since it's mostly based on the setting of cookies and tracking people across websites, you can go on and set, no third-party cookies and take care of 90% of that problem. People don't do it. But there is an answer also in technology. So I think we can look to law and policy, but we're also going to have to look for the creation of more technologies that give consumers more control. Whether we can get them to use it, I think, is a really open question. But I don't think that in the face of technology, law policy wins by itself without arming people with some technologies as well to protect them.
That's great. Melissa, can you respond to Leslie's point that it may be too late to pass a law once everyone is on Google? Before that happens, we can create technologies of control that would make it easier for people to get off Google than it was for you to fix your passport problem. But at some point, it might be too late, I think Leslie is suggesting. So to what faith do you have that technology, rather than law or policy, may save us?
I think that it's difficult because what happens is that people say, oh, look at what technology can do. Because technology can do this, because technology can invade my privacy rights, because it can track me, then it's okay for this to happen. I mean, that's what I hear often, almost every day, is because, oh, well, if you couldn't do it, then the technology wouldn't be out there allowed to be able to watch you, to be able to track you through RFID, to be able to gather all of this information up about you. And I think that that is one of the biggest problems, is because people believe if the technology is there, if it's able to track you, then it's okay. The reason that my site is Privacy Lives is because I firmly believe that there are attacks on privacy every day, but that there are people and there are instances where people stand up and say, no, this is wrong, and I want to fight back. I think that Leslie's right in that people don't want to use their privacy-enhancing technologies. If you think about it, almost every single day you hear about yet another company that has lost an unencrypted laptop. They've lost an unencrypted external hard drive. They've sent unencrypted CDs through the mail. All of this is happening even though it is extremely easy to encrypt your information. It is one of the basics of security, encrypt your information. Why don't people do it? Because it can be a little bit tough. When I try to move my encrypted information from one place to another, it takes several hours because there has to be a process to decrypt, move, re-encrypt, and figure out if the re-encryption is enough or if I have to re-encrypt on top of the re-encryption. It's not actually hard, but it is a lot of steps, and that is what makes things difficult for the everyday person. They don't want to think about it. They want to be able to trust that if they do nothing wrong, then it won't really matter. But the problem is that in this day and age, it has come to a situation to where if you do not agree to allow your privacy to be invaded, then you are suddenly a person who should be looked at more closely. And in terms of how to stop it, what to do, I think that you can look at laws, but I think you need to look at it differently. Instead of trying to play catch up and saying every time, okay, well, this technology has invaded my privacy, so I have to stop it in this manner, and we pass another law. It has to be broader. It has to be, this is my information, and in whatever form it takes, in whatever way in which you can get it, you must follow these procedures. There must be certain protections.
Very good. Marcy, do you want to sum up this portion, and then we're going to open it up to questions? We've talked about various ways of protecting privacy. We've had concrete laws proposed. We've talked about judicial doctrines. We've talked about executive leadership, and now most recently we've talked about privacy-enhancing technologies that could, in theory, protect privacy and security at the same time. But we've struggled to imagine a scenario by which all the pieces would come together in a way that actually would protect us against this ubiquitous surveillance scenario, or even more concrete ones closer down the road. How optimistic are you that the stars will be aligned and that good laws, good technologies, and good executive decisions actually will or won't protect privacy in the next 20 years?
I'm actually relatively optimistic, and here's why. I think that there is emerging and will emerge a combination of a legislative regulatory regime, but it's also going to be the power of people organizing themselves, that norms will emerge. The key to having those norms emerge and having, one of the things that the internet also does is it lets people organize themselves and let their opinions be known in very effective and powerful ways, and we're only seeing the beginning of that. And Beacon is a good example. The issue is, and this is what I started with, the more transparency there is, the earlier on, folks will have a visceral reaction. If folks know that the Google world you described is coming, right, they will then brace for it, they will know how they feel about it, and they will be moved to action. The key is going to be timing, and will it be too late? And so to use these tools, the political process is one process through which folks get educated. There needs to be more in daily life, and the types of invasions that are coming need to be visible sooner. It's not after Beacon is put up, but there needs to be a sense that this is coming. So I think norms will emerge. I think that opinions will be voiced, and the incredible power of folks coming together in ways they never did before will put a brake on what particularly commercial stakeholders can and will do.
Very good. Many thanks to our panelists for introducing the subject so well, and we now have some time for questions. Yes, sir.
Getting back to the question of consent, with what information is needed by the average consumer from an ISP or content provider to provide knowledgeable consent to a service? And once we get past that question, then what effect would new services and features have on that consent? Would you have an idea of some type of evolving consent, or how would you change your consent or remove your consent to live video feeds from Google or something like that?
Leslie, do you want to start with that?
Sure. So here's what we know about online consent, that it hasn't worked. The average person thinks if they see a privacy policy that it means no data is collected about them. So that's where we're starting from. I mean, to give meaningful consent in that context, to say, behavioral advertising oversights. So first of all, you'd have to figure out a way to provide enough information that people even understood what this meant. It's not easy. They'd have to understand what a cookie is. At this point, my mother would be in the kitchen. You'd have to understand the legal framework. I mean, if you're really talking about consent being the answer, you'd really have to understand what it meant for somebody else to be holding all that information over time, not just, the ick factor that they're going to send ads back to you. And I haven't seen that work. I'd like to think it works. I think that, and you'd have to do it at every place you go. And buried in terms of service could not be something that says, and we may change what it is we're doing with your data or which data we're collecting, and you're also consenting to that. And there would have to be some meaningful way to revoke that in a context where, at least if you're talking about, the commercial setting, the person, the site you're dealing with is not the ad network itself. It's another third party who is acting on behalf of a whole other sets of, I guess, fourth parties who are the advertisers. So you're going to be asking a site or an ISP to get consent for practices that they engage in, that some known third-party advertising network, some set of advertisers, and somehow you'd have to know all the secondary uses that you don't yet know that they're contemplating. So that's why I don't see consent as adequate.
Do you want to say a word for consent, Marcy?
I want to say two things. First, it's a great question, which is, well, how do we get meaningful consent? And I think the answer is, to the extent you can do it, there needs to be some kind of a standard format and standard categories that people can understand. It needs to be short. Because now what you get are, if you look at privacy policies on websites, it looks like a mortgage document. Who reads a mortgage document? Nobody, except the lawyers. So one is, how do we shorten it? How do we get the right categories? How do we standardize that format so that people can compare apples to apples when they're looking at websites and Internet services? The second is to recognize that, and Leslie was touching on this, consent is meaningful to a point, but, and I'm going to give you a healthcare example. I'm going to consent to my healthcare provider using and disclosing my information so that they can be paid for the services that they provide to me. And what that means, what you think it means, is that, my healthcare provider is going to tell my health plan what service I got, and then the health plan is going to send money to my healthcare provider. But no. The healthcare provider's practice management system is going to send the information through a series of switches various clearinghouses. First, it might go to a billing service, then it'll go to a clearinghouse, then it'll be routed to a health plan. All those middlemen, somebody might take a stream out of de-identified data and sell it in the aggregate to pharmaceutical companies. Somebody may dip in to utilize it. The health plan may take it and use it for quality assurance. The health plan may use the pharmacy, right? If it's a pharmacy claim, may use it for a number of reasons. It may use it to send me reminders about when my refill is due. It may use it to send me information about coupons that pharmaceutical manufacturers are offering. Once I say yes, you can use it for payment. Payment means so many things and touches so many places. There's no way. I don't have a way to consent to what happens after that claim is launched. And so there's just a limit. Once I consent to one use, that data is, think about it as copies, is copied so many times. And all those folks in the middle may be maintaining a copy and using it for their own purposes, that unless you're going to say you're going to consent to these specific purposes and then understand, which HIPAA does, understand that once it's disclosed, we don't know what happens to it. That's really, that's about as much notice as you can get in a number of contexts. So I think, yes, we have to do something to standardize the format and make it meaningful, but also understand the limits to that control and consent.
Just very quickly, I think the idea of a standardized approach to privacy policies is a fantastic idea. And think of how that might work. So in the same way that we have Creative Commons, for those of you that are familiar with Creative Commons, standardized copyright policies, you can actually understand what rights are granted and given away, and it's right there, and you can look at the license. How about standardized privacy policies, where you can look at it and actually know what rights you're giving away, and not choices companies could easily make, which of the standardized policies do we want? I think it's a great idea, especially for a private organization, to pick up and standardize some of these policies.
And in terms of making people read them, I learned recently that YouTube discovered people don't read privacy policies, but they do watch privacy policy videos. So if you go to YouTube, there's a quick little thing, and that solves a lot of the problem. Yes, ma'am.
Cookie videos.
The Ninth Circuit recently held that if you cross the border, if you're an American citizen and you come back from overseas travel, you don't actually have any sort of Fourth Amendment rights at the border coming back, so your luggage can be searched, for example. Anything that you're carrying with you can be searched. And that's generally the jurisprudence of Fourth Amendment on the border. But the Ninth Circuit recently held that that also applies to the contents of your laptop.
Right.
So the customs officials can open your laptop, read your documents, look at what websites you visited, et cetera, et cetera. And the holding was essentially, it's no different from, if you're carrying a book, they can look through your book, that sort of thing. And leaving aside whether or not that was actually the correct constitutional reading, because they actually can't search your person because you have a privacy and dignity interest in your person, and arguably that should apply to a laptop as well. Are we at a point now where technology has outstripped the current constitutional protections that we have, in that obviously nobody who was involved in drafting the Bill of Rights could have foreseen traveling across the border routinely with a laptop? Do we need a constitutional amendment for privacy?
Great question. Luckily, we have in this room the world expert on computer privacy. Take it away, Professor Kerr.
Hey, Leslie. It's a great question. The Arnold case in the Ninth Circuit is currently pending rehearing en banc. I don't think it'll probably get enough votes, but it'll probably get some pretty strongly felt dissents from denial of rehearing from some of the members of the Ninth Circuit. This is a really hard question, I think, because what should the rules be? Just taking the case of laptop computers at the border, I think it's. I certainly feel, and I think a lot of us feel, that in the case of a typical individual, it's outrageous that the government can search through their entire laptop without any reasonable suspicion, without anything. I mean, it's really just, it's a tremendous privacy invasion, and it's outrageous to think that just because somebody's passing the border, that the government should have that power. And then on the other hand, we think, if somebody's bringing in contraband or bringing in terrorist plans, bring in whatever might be in the laptop crossing the border, the government should be able to stop that. And coming up with a good rule that distinguishes those two cases is, I think, really, really hard, which explains why the Ninth Circuit sort of didn't quite know what to do in the Arnold case. Said, well, it's the same as everything else we've seen. We don't know exactly where to draw the line. In terms of whether a new constitutional amendment is needed, I think the difficulty is once you add a new provision, then the courts need to interpret it, and it's great. I mean, it'd be fun for law professors because we could sort of play with that new amendment. The old ones have been around for so long, and we still play with them. Just 200 years later, we're going to still be, what does the Fourth Amendment mean now? Mean in the space age is going to be what they're going to be. Law professors are going to be thinking about 200 years from now. But I think it's hard. I think the question is, what would it mean? I don't think there's really a lot of agreement as to what the rules should be, and until we get that agreement as to what the rules should be, it's too early to think about a constitutional amendment or any sort of specific statutory change to do that. But statutory changes, I think, are where the action should be. And I think, is it the Senate or the House that's having a hearing on this? I think it's the Senate side, I'm not sure, is actually having a hearing on this exact question of border searches next week or the week after or something like that. June 25th.
Great.
There you go. So I think it's certainly a viable question for Congress to address.
Melissa, you want to jump in? What should the rule look like? Shouldn't it be at least like a strip search and you need reasonable suspicion or higher?
I believe so, because when people think about it, what do you think your laptop actually is? Do you think that it is just a book? Do you think that it is just a couple of pages of documents? Or is it more like your thought processes, what you're thinking about, what you're caring about, what you would probably not tell everybody at all? And so, yeah, I definitely think that there should be a high standard to where there has to be reasonable suspicion to be able to invade your mind in this manner. And once again, we can talk about privacy-enhancing technologies. Companies have been sending their business people across the border with clean laptops with absolutely no information on it and the ability to log into a virtual private network. But there's also the ability, if you can't do that, to encrypt your information to where not only do you have the sensitive information encrypted, but what you can do is you can have the even more sensitive information hidden, and when they want to unencrypt your information, you can have the sort of sensitive information opened up. They go, oh, okay, this is the only thing there, and they don't notice the information over there that's been hidden. Sounds great, right? How many people are actually going to do this? That's the problem, is that there are technologies out there in order to try to help you protect yourself right now, but people don't use them and people don't really understand them. So that's why I just don't think technology is going to be helpful. I think that there really does need to be a comprehensive law, possibly a constitutional amendment, that talks about how your data is yours, whatever form it may take.
I just have to follow up with the other panelists. Why do we need an amendment? I mean, is there anyone here who doesn't think that it's extremely invasive? I've just had this hellacious flight from California. Something was canceled, up all night. I've been living on this thing for the past 24 hours, writing articles, reading, browsing. It would be absolutely as much of an indignity as a strip search to have this looked at on low cause. So why isn't the current Fourth Amendment, which at least requires a higher degree of cause for strip searches, adequate to deal with this problem?
Oh, I'm not sure the Fourth Amendment isn't adequate. I just think we're not interpreting right. We don't get a lot of cases that make it to the Supreme Court that allow the jurisprudence to develop. I mean, if we're still pretty much relying on the business records cases, et cetera, from the 70s, and of course what's happened is once you start getting those cases that say that you don't have, and this is not specifically about the border question, that you don't have a cognizable privacy interest, then you have all these third parties holding kind of data that's sensitive, and there's enough computing in the clouds going on. But so people are holding this data. It's accessible under low standards, and you don't have to have notice. So what's happening in some ways is the jurisprudence isn't developing because those bodies do not necessarily have any interest in challenging the acquisition of that information. Occasionally you'll get a case that does, but it means we're kind of stuck. So our jurisprudence needs to develop. But I completely agree. We need to do something statutorily. I mean, ECPA is 20 years old. We have no comprehensive privacy regime, and Melissa's right. We adopt, what I call the privacy, horror of the day law. So we'll have, massive hearings around some. For those of you who are too young to understand why we're a country that has protection for video records and not for, books, you had to be around, 20 years ago during the Bork hearings for the Supreme Court when, a local video provider released records of his video rentals. Well, this was an outrage. So, having been part of the group that actually participated in passing this law. I was at the ACLU at the time. So we now have a video protection law, but we don't have it for, the purchases of your books. We don't have a national law about your library records. So we have just, a set of incomprehensible and, largely outdated privacy laws. So before I'm willing to say that we need a new amendment and that the Fourth Amendment is inadequate, I think we have to figure out how to give full force to the Fourth Amendment, and we just haven't in this area.
Good. Yes, sir, in the back. All the way in the back. Yes, sir.
With respect to the arguably unconstitutional warrantless interception of various wire communications, what's your best estimate of the liability? Secondly, do you think there's personal liability under Bivens or otherwise for the federal official or officials who have participated personally and substantially in arranging for the allegedly offending activity? And if your answer is yes on the personal liability, why do you think that has played essentially no role in the consideration of the proposals for immunity?
Great. I think we may have some differences of views on those questions. So once again, Oren, why don't you just start?
Oren, it's a law professor question,
yeah.
if I ever heard one.
I was going to try to pass it.
Bivens, does everyone know?
Actually, went to law school forever ago.
You want to translate, or should I? Why don't you, in broad terms, I think you're being asked.
Well, the basic question, suing somebody for a violation of your constitutional rights. There are a lot of procedural hurdles to all of these claims, even if they are there on the merits. Procedural hurdles ranging from standing. You can't sue under the Fourth Amendment unless you have actually been searched. How do you know if you've been searched? Well, you need to know if you've been monitored. How do you know if you've been monitored? You need to get disclosure of the monitoring that's occurred. How do you get that? You run into the state secrets privilege. And wait a minute, you're stuck. The walls close in pretty quickly, and it's really hard to get relief in that way. And then there's qualified immunity, which would come in as well. There's all sorts of procedural barriers which get in the way of a resolution on the merits.
I feel better. I could have answered that question. Who knew?
Very good.
You might assume that there may be a state secrets privilege asserted under this administration, and that's sort of open to every administration whether they'd assert it. There's also a prospect that if there were a change in administration, say next January, the next administration might decide not to assert that privilege.
Right. That is true. That is definitely true.
Yes, sir.
Going back to the immunity question, it seems like we don't learn from our own history. One of the Nuremberg trials involved 16 members of the judiciary and the Ministry of Justice. And what we said then, the United States said was, we don't care about the memos you got saying that it's okay to do this. You violated the rule of law, therefore we convict you.
Yep.
Just clarify, this is immunity for the ISPs that you're thinking of, or immunity for the individual?
I think we're on the Bivens questions.
Well, immunity for the government giving the immunity to the ISP.
Right. I mean, in the case of immunity for the ISPs, there's a specific provision of the law that says if the government gives you a certification, you're not liable. So
Right.
The question of what's the rule of law answer? Do you follow?
And we said tough luck. We went after both of them.
Well, I don't think we're in Nazi territory.
I think that we're in almost the same time.
Well, then we should amend the Wiretap Act. Get rid of that exception.
I mean, no, we don't have someone like same environment of giving memos saying it's okay, and then the United States says, you the actor and you the person that gave the authority, you both violated the rule of law and we convict you. And we did it at Nuremberg.
Or just because there's some skepticism about immunity, what's the substantive reason for it? I know some smart lawyers came up with this argument that it was required by the nature of the deal, but people feel really strongly about this, especially on the Republican side. What exactly are they concerned about? Why is it so important to immunize the telecoms?
Looking prospectively, you're saying. Yeah. I think it's hard to break down exactly where people are coming from on the immunity question. I think part of it is probably just a sense of, this is lawsuits which are going to go on for years, stop them now, because ultimately these, our understanding at least is that the certifications were given, so ultimately this is about getting discovery of what happened. This is sort of not really about getting damages, it's just about using the judicial system to figure out what happened a few years ago for entirely different reasons unrelated to the official claim of the lawsuit. And some people will say that's great, that's what the legal system's for. Other people will say it's not. And I think it's a disagreement, also in part just over whether this was lawful or appropriate for the government to do. Some people think it was, some people think it wasn't, and those that think it was lawful want to obviously not have a lot of litigation over this question for years. That's at least my understanding. I mean, and I should say I'm personally on the question of immunity. I don't think the immunity deal really changes a lot because the state secrets privilege is going to block these lawsuits anyway. So it's a question of whether the lawsuits get sort of killed now or killed over sort of 5 years of litigation. So I don't think the stakes are that high, really.
Very good. Yes, sir.
Leslie, what I want to ask you is putting aside what I want to ask you is putting aside the harmful aspect. Do you really think that people do care about privacy? I'm going to put you on an Amtrak train as an example. Not the quiet car, but the regular Amtrak.
I was going to say, put me in the quiet car, please.
Do you hear what's going on on cell phones?
Yes, I do.
People have complete control.
Yes.
They know exactly what's happening. They readily give consent. They don't care about privacy except where it harms them. I mean, do you disagree with that?
No, I think I probably don't disagree with that. And I've been on that train, and next to me somebody was raising money for Clinton, and on the other side somebody was doing an enormous deal that was subject to attorney-client privilege, and I know the name of all actors involved, and behind me there was a young woman sobbing and breaking up with her boyfriend. And it was like, what am I doing here? No, I agree with you, but I just think culturally our norms have changed, and they're not changing in the direction of privacy. They're in the direction of a certain amount of exhibitionism, if I can say that word. And I think that does cut against, the legal changes that we need to protect people, whether or not they understand what the implications are. I think that's a given. I think that the Facebook incident, to me, is that people are oblivious until such time as they see it in a very transparent way.
They don't think that's true, but
and then suddenly, they're surprised. I mean, the call that I get constantly, that I'm always kind of like scratching my head, is from somebody who has a very public Facebook page or MySpace page, and in some particular community, there's a crime committed, and the police sign on and become part of that particular social networking group, and they look at the public information. And then I get all these calls from people who are shocked. So, it's a combination of people not even understanding. I mean, I think the public understanding right now of what's collected, who can see what, and whether it matters is extremely low, except in the healthcare setting. Right. And then people get it.
Or employment.
Or employment, but we don't have something like, a massive move of all of our healthcare information into a digital environment that can sort of like organize people to get that. They care about employment, so they'll care about healthcare because they're worried about the impact on insurance or employment. But sort of in any kind of broad way, I think you're right. I have, 2 children sort of right in the right demographic, and they don't get it when I tell them that there are things on their pages that, you know, they really ought to take down.
Melissa, are you less pessimistic than Leslie that we're doomed?
Yes. Privacy lives, people. The reason is because as more and more of these incidents happen, as more and more people see that the children of presidential candidates' MySpace pages, their Facebook pages, the photos are taken and splashed across the New York Post, as people learn about how you can be so exposed, I think that people, whatever generation we're talking about, will sit there and say, think about exactly what it is that they're putting out there. They're going to think that they have control over the information, and that's the problem right now, is that they have yet to understand, even though there have been these high-profile incidents, that there really is no control once you put it out there into the digital domain. So I firmly believe that as the incidents keep piling up, because they will, that people will start to step back and understand that they do need to believe that their information should be private, not just private from their parents. So therefore, they'll be better about not putting it out there.
Good. Well, we're out of time, but I think this is a good note on which to end, because we've had a pessimistic view that we're doomed because people really don't care about privacy, but then an optimistic note from Melissa that at some point, everyone will reach the point where they gasp, just like that lady did in the front row, and they'll say, we're not going to take this anymore, and they will stand up for privacy. And in that sense, the moral of this panel is that the courts can't save us, the White House can't save us, technology can't save us, the only people who can save us is ourselves. Thank you so much for joining us.